Good morning and welcome to the J&J Consulting Services Investor Call. Today is May 27th, 2025. It is 10 a.m. Pacific Time. I appreciate everybody taking the opportunity to join the call this morning. I apologize that we had to move the call from last week. Unfortunately, I had come down with COVID and was unable to do the calls last week. So I appreciate your patience and being able to reschedule the call till this week. A couple quick disclaimers, as usual. Nothing in this call should be construed as legal or accounting advice. If you have legal questions or accounting questions, we recommend you reach out to competent counsel or competent tax preparer in order to assist you with any questions you might have. Just getting into the kind of the timing of what's happening, as we've gone through this list before. So everyone's aware, the initial timing of the events, we in the beginning, start marshaling assets, do an investigation, complete a forensic accounting, do asset sales, begin a claims procedure, talk about third-party litigation, taxes, distributions, and the like. So currently, as you guys have likely seen, we did issue our forensic accounting report at the end of March, as we had promised. And now we are working towards the process of getting the claims procedures drafted and submitted to the court so we can begin a claims process with the ultimate goal of then doing a distribution once the claims have been set. So we are beginning that process. As part of that, of course, we are still looking at selling assets that we have in our possession, looking at recovering additional assets that have been determined through the forensic accounting process. We are working on third-party litigation, both with banks, Wells Fargo Bank, as well as others. And then, we are looking at potential clawback actions against third parties for commissions paid, as well as, potential net winners. So that's all being evaluated and will be presented to the court and for the court's final approval as to what they determine is the best way to move forward with those particular actions. First question that we have from investors is, if you're communicating directly with investors, can you publish on the website what you're doing, to whom, and why, so that the investors know why or why not they are being contacted? Yeah, we do try when we send out letters to investors, we try to send out an email along with it, letting investors know that we will be reaching out. We have not necessarily always done that, but it is our goal to do that so that investors know that they are being contacted by us and not by a third party who is attempting to get something from them that they're not entitled to. If you ever have questions about a contact that you receive, do feel free to reach out to our office. We are happy to walk you through what it is we're doing or not doing. In addition, if you have questions about the specific things that we're working on, I would encourage you to read our quarterly reports that we file, and that would allow us to give you some ideas of what it is that we're working on. The next question has to do with somebody mentioned that a private company had been offering to buy out their claims, their potential claims, for 22% of their value. The question is, what do they know? Where are they getting that figure from? Are they associated with us? We did send out an email to people letting you know that we do not give out claim information or investor information to any third parties at all. In fact, even when it's filed with the court, it's filed under seal. So that information is not publicly available. So if you are getting contacted by third parties, these are people that are reaching out based on other information that they have received from third parties that are not us. Whether or not you should sell your claim at 22%, that's obviously a legal question you'd have to ask. Where they come up with that percentage, I don't know exactly where that number comes from. However, if I do a little bit of math, I think that that's based on a very conservative guess of what, if we were to do a distribution today, how much that would be. Although, we do think that number, it would be higher than that number. I do think that that's kind of where they're coming up with that percentage. My recommendation to investors would always be to wait for the claims process and distribution process, because that's going to allow you to maximize the amount of money that you're able to get back from the estate doing it that way. Again, if you have specific questions about it, then I would recommend reaching out. We have not yet set the claims process. We are in the process of drafting it and putting it together. However, as of today, we have not proposed, and the court has not approved any type of formal claims process, let alone confirmation of what investors might be entitled to allowed claim and what that claim amount will be and what any distribution amount would be. So as far as the sale of the claim, again, we take no position as to that, but I would encourage everyone to reach out to competent counsel and discuss with them, as well as the fact that, we do believe that investors will be getting back greater than 22% of their claims. And so, you should have that information available to you to make that decision. Can you update the FAQ section of your website to provide current answers on previous questions and answers to new common questions? Yes, so I've instructed my team to work on this and update the FAQs to become more relevant for the step that we're in right now in the receivership process. And so that will be done here in the following days. However, if you do have specific questions, you are always free to reach out to us either via email or telephone and ask those questions. Next questions. Defendants and parties. Are you sure defendants are not living off the ill-gotten gains? We do not believe that they are. We froze all the accounts that we had learned about throughout this whole entire process. Is that to say that it's not possible that there's an asset out there that was missed? No, absolutely not. I mean, it is possible that something may have gotten missed in the process. However, we do think that we've captured, what we know about. If you do know about something that you think we do not know about, I would encourage you to reach out to us and let us know what that might be. We're always looking for additional assets, and so we're happy to investigate if you guys even have any idea whatsoever. I think I've said it in the past, but I'll say it again, that investors are oftentimes a great resource for us in finding additional assets that we may or may not already know about. Why is there no lawsuit against Jeff Judd and Shane Jagger for not turning over all the funds or assets? The question about lawsuits is, the court order requires the defendants to turn things over. We are still working with some defendants on turnover. Part of what we were trying to figure out is how much money it was that they had taken and how much money they might owe. Now that the forensic accounting is done, we have that information and we are moving forward with collecting all outstanding monies due to the receivership estate, and we'll be collecting additional assets from these defendants, as well as setting up payment plans or whatever else might be necessary to continue to recover money. There's some questions about specific balances due that the defendants each owe. We won't get into the details of what those numbers are. They are all in the report, but they had questions about how it's possible to spend that kind of money and some other things. But generally speaking, the money was spent on pretty typical things: housing, vacations, parties, as well as cars and other types of assets. And so how much money they spent and how they spent it really is too much detail for a call like this. However, I do encourage you, if you have not already, to read the forensic accounting report, as it's full of good information that would help explain those things. Next question. What is the plan for going forward after the bookie and Judd's adult kids for recovery of their ill-gotten gains? So we are actually looking at recovery of any third party that received ill-gotten gains and determining a path forward. So we will be filing motions with the court in the coming months to allow us to sue in order to recover those ill-gotten gains and false profits. Is it possible to list all the money recouped and assets sold by each individual promoter? So we do actually gather that information, and if you read the quarterly reports, the quarterly reports do break out what has been sold. But as far as how much was recovered by each promoter, we have not broken that out in a public report. And so we will look into and make a determination as to what the best way to do that might be, whether it be in a subsequent report or in another filing, and try to figure out the best way to do that. Will promoters ultimately be held responsible for any loss not recouped? Yeah, the promoters, the defendants in the J&J scheme are working out their liability with the Securities and Exchange Commission. In addition, the receivership itself has claims against these parties for any losses suffered by investors. And so we will seek to go after defendants and other third parties who have received ill-gotten gains, and we'll seek to recover those. Next section has to do with litigation and third parties. Can we get an update on the Wells Fargo suit? So the Wells Fargo suit, we have gone through various different stages of discovery, as well as expert reports and expert turnover. That portion of the case is now concluded, and we do believe we're working right now towards attempting another mediation where we can get together and attempt to settle this. But outside of that, we are continuing to move forward and preparing for trial, and we'll continue to do so, until we can either get it mediated and settled or it goes to trial. Next question. If we're successful in a settlement with Wells Fargo, does that help all investors or only those who made transfers with Wells Fargo? Our goal, so any money that's recovered in the receivership estate, outside of a court order that says otherwise, is distributed amongst all the different claimants of the estate. So that means anybody who's owed money to J&J will receive distributions out of any of those monies recovered, whether it be Wells Fargo litigation, or assets being sold, or third-party litigation against outsiders. All those funds will be pulled together and will be distributed to all investors. On a 1 to 10 scale, what would you put the odds of either winning the lawsuit or getting a favorable settlement against Wells Fargo based on the current information you have about the case? I think the easiest way to answer this is that, in these cases, we make determinations as to whether or not the cost-benefit analysis of seeking this type of litigation versus what it will cost to do it and what we would hope to recover. So what I would say is that, we would not have sought this litigation out if we did not believe we had a strong case against Wells Fargo. Nothing I've seen in the evidence to date, as well as the forensic accounting report that we filed at the end of March, all those things lead me to believe that we have an excellent case against Wells Fargo and will continue to move forward on it. For the Wells Fargo case, if they're liable, why can't we go after them for the entire loss that the investors suffered? So our claim against Wells Fargo is for the entire loss of what investors recovered. However, what we ultimately win is going to be up to a jury. If it goes that far, if in settlement, if we determine that we need to settle it, then that settlement information will then determine what the actual recovery cost is. There's obviously always risk in taking a case to trial. So if we do determine to settle it, it's going to be based on the fact that we think that it's in the best interest of all the investors and moving forward. The other thing to keep in mind is, though, although ultimately I have the final decision as to whether or not we accept a settlement from them, the court actually will have the final say as to whether or not a settlement is acceptable. So if I determine in my business judgment that a settlement makes sense in a certain dollar amount, we will then present that to the court, and the court will have the final say as to whether or not that is an acceptable amount of money. During that process, we will file a motion that will give all parties an opportunity to be heard. And so if you have specific questions about what number, why we chose to accept a certain number, then, do reach out to us, and we're happy to talk about those things. Will the receiver be pursuing third-party recovery efforts like banks, promoters, facilitators to increase the pool of available assets? The answer is yes. We will ask the court for permission to go after third parties in order to continue to recover funds. And we will be looking at, all parties that we think have some responsibility for furthering the scheme, whether that be banks, professionals like attorneys or accountants, as well as promoters, facilitators, poolers, those types of individuals as well. A question about the standardized fund accounting report, which we file as part of our quarterly report every quarter, about the third-party litigation, trying to figure out where that number comes from. That number we believe is a fair estimate of what we think that the value of those claims would be, but they are not a guaranteed recovery amount. Obviously, we still have to determine what or the court may have to determine what the value of some of those assets are, as well as determining the collectability on some of those assets. So what that final number is or will be will still be up in the air as we go through the process, but that is a fair estimate of what we think that the value is. Questions about the forensic accounting report. It says in the filing that $246 million is owed to investors, and to date, $82 million has been recovered. Can a portion of this $82 million be dispersed immediately? And if not, why? So the answer to the question is yes, $246 million is what we believe is owed to investors approximately. Approximately $82 million has been recovered and liquidated into cash. And the question is whether or not it can be dispersed immediately. The answer is no, because in order to do the disbursement, we have to finish the claims process. And so that's why we're working on that piece now. We do hope to get that filed here, as quickly as possible. We are working through some last minute calculations with some of the defendants as to what their restitution will be. And we've also requested a little bit of additional information from some specific investors regarding pooling and things like that. But we are working towards getting that claims motion on file as quickly as possible. I think I'd said previously that our hope was to get it on file by June, and that is still our hope, is to get it on file in June. But we are continuing to push towards that and get that done as quickly as possible. We do hope to get a distribution done as absolutely quick as possible. We explain the conclusion in the forensic accounting report. The forensic accounting report obviously draws a number of conclusions, including whether or not this was a Ponzi scheme, who was involved in it, what level of involvement did they have. From our perspective, we don't determine who's guilty or innocent in these cases. However, we do report the facts as we see them. And so that's what we did in that report, is we reported based on what we found in doing our work and what we think those conclusions were based on that. If you have any specific questions related to the forensic accounting report, again, do feel free to reach out, and we're happy to talk about them at the time. Next question is, am I interpreting the forensic accounting report correctly that defendants Siebert, Johnson, and John Ward are the closest to making full restitution? Yeah, as of the date of that report, that is correct. That those are the three defendants that have the least amount of money that is still outstanding as far from a restitution standpoint. And that, of course, is a calculation done by the SEC to determine how much they believe that those defendants owe back based on what they're allowed to go after and seek to recover from the defendants. Next question is, what is the timeline in the court confirming or endorsing our forensic accounting report? We have filed it with the court. Typically, the court will review all those filings at a quarterly hearing that we have. I believe the next hearing is scheduled for the month of July, and so that is the time frame that I would expect to get that answered. And so that would be when we would expect to see something from the court. Next question has to do with clawbacks. Will the receiver initiate several legal or clawback actions against referral agents or promoters that are not currently named defendant in the SEC action? Again, we have to seek court permission to do so, but it is our intention to go after those third parties and seek to recover any commissions that were paid out as a result of that. Do you plan to go after net winners, the 253 investors and 83 non-investors from the report? Again, a final determination has not been made on that, but it's likely that we will seek to go after net winners and recover those funds since they are not real profits from a legitimate investment source. Has the investigation reached the point of contacting net winners and have any of the net winners paid back their gains? To date, I do not believe that any net winners have paid back their responses. Their net winnings, nor have we asked them to yet at this point. However, that is something that will be happening here very, very shortly. Again, once we get court permission to do so. In an earlier meeting, it was brought up that the LDS Church had funds from tithing. Is it possible to get that back? Yes, we have spoken with them in the past, and we will continue to speak with them in the future. We needed to finish our forensic accounting report in order to start that process, and so that will be done as part of the clawback process against all parties. Will clawback actions be pursued against investors who profited or withdrew funds, and will those recovered funds be used to repay victims? So again, the final decision has not been made yet, but it's likely that we'll be doing clawback actions. Before we initiate any litigation, we will usually reach out and ask people to return a certain portion of their net winnings, as opposed to just filing suit against everyone, off the bat. Will those recovered funds be used to repay victims? The answers would be yes. Any money that we recover will be used to pay victims back. How much money do you estimate you can still collect from promoters and investors who profited from the scheme? As you saw, we provided the numbers in our forensic accounting report of how much money that is. However, as we've stated in the past, it's never possible to collect 100% of that money. What percentage we ultimately end up collecting is nearly impossible to say. However, we do attempt to recover as much of it as possible. Claims process. What documentation or information should I be gathering now to support my claim or improve my chances of receiving restitution? Our goal is that you won't have to actually provide us any documentation unless for some reason you disagree with our accounting of your claim. So at this point, I would say that there's not anything necessary to be gathered unless you know you have a claim that may be difficult due to the way you invested, whether it be through a pooler or some other way. But otherwise, we do believe we have all the information about how much money each investor put in and how much money they got back. So it's very unlikely we will ask you for any information. With the forensic accounting now complete, what steps remain before the claims process can begin? Again, there's just a little bit of cleanup work that we've done with some information that we've requested and received. And so and the claims process is, we've begun drafting those documents, including the claims form and all the other pieces that go along with it, and do hope to have that on file with the court here very shortly. Once the claim process starts, we will file a motion with the court. Once the court authorizes, it will set a time period at which claims will start and which claims must be submitted by. Once that process goes forward, we will begin auditing claims as we receive them, to the extent they need to be audited. If it's possible that they agree with our calculations, then those claims will obviously go much, much quicker. And then, based on the number of claims and when we receive them, that will affect how long it takes us to review those claims prior to filing a motion with the court to accept our determination of the claims. So I would encourage people, if you are a claimant in the case, that once that claims process starts, please try to get those to us as quickly as possible. And don't wait till the last moment to file your claim, because the more that we can process ahead of time, the shorter the period of time is that we'll need to get them processed and file that motion with the court. And of course, after the court approves that motion, the next piece of that is the distribution motion. And so we need to get that done and as quickly as possible. So we would encourage you to get that done. When do we start our claims process and when does the time expire? So the process again will start once the court approves it. The court will approve it with a start date and an end date. And that time will be determined, by the court. Typically, the claims process will be 90 days. So you'll have approximately 90 days to get your claim filed. We will not only send out information to people that we have contact information for, but we will be filing notices in newspapers of general circulation that we believe will give us the highest likelihood of reaching out to everybody who could potentially have a claim. Distribution process is the next group of questions. Once we pass the deadline for claims, when can you expect our first distribution? So typically, once we file our omnibus motion regarding claims, once the court has approved that, we will usually file our distribution motion either at the same time or very, very shortly thereafter. Again, there will be a time period in which the court will review that. They'll have a hearing on it. And once the court approves a distribution, checks will usually go out within 7 to 14 days after that date. So it will be our goal to get those paid as quickly as possible. Are we still on track to get some sort of payment within 2025 as previously discussed? It is still our hope that we can get a payment out in 2025. We're going to do everything we can to make that happen. There are some things that are out of our control, and so we don't have control as to how long investors take to file their claims, as well as how long it's going to take for the court to act on them. And so we can't guarantee that, but that is our hope. What is the likelihood of recovering any portion of our lost investment? You will recover some portion of your lost investment. What that percentage is, unfortunately, is not known at this point and can't be known. There's going to be a lot of factors that go into that, including the Wells Fargo litigation probably being the largest of those factors right now that is unknown. And so that will ultimately have a big influence on what the total amount to be paid is. Do you have any formula for how payments once started will look like? Again, we haven't filed the distribution motion yet, so we haven't made a determination. However, I can say typically in a receivership case, most the time that the payments are done on what is known as a pro rata basis, which means that everyone will receive the same percentage of their approved claim. So for example, we may send out and this is just an example, but we could send out a 20% payment, and that means that anybody who has an approved claim would get 20% of that approved amount paid to them as part of the distribution. Next question is, are there priority investors to return funds? And if not, is the plan to take all the money received and divvied out based on a percentage of what was invested? Yeah, that's what I was just talking about, is the pro rata distribution. And that's typically how they're done in these types of receivership cases. Can you briefly discuss what our payout might look like if we were to recover 100% of the funds, but then subtracting all the legal fees? So the legal fees are paid out of the funds that are available, and then the remaining funds get distributed out pro rata. So that is the same, meaning that everyone will receive an equal percentage of what it is that they're approved for in their claims process. Is there an order to who will be paid back first? That we don't pay back investors in different categories in this type of a case. All investors will be paid at the same time, unless for some reason there is something that prevents the payment of their claim, whether it be a lack of if a check bounces back to us, or if we're needing, for example, a tax ID number that we have not received it, the court may ask us to withhold the funds until we receive the information we need. But those are very, very limited cases, and so we don't anticipate any wholesale issues whatsoever. So that's the last of the questions that are here. I do want to, before I peek at the questions in the chat, just remind people how you can get in contact with us. There's the two easiest ways to get a hold of us are contact at jjconsulting-receivership.com. Again, that is contact at jjconsulting-receivership.com, or you can call us at area code 702-832-2299. Again, that's area code 702-832-2299. And if you have not already, I do encourage you to go onto our website and register, so you can receive receive information like emails and other things that we send out, updating you as to what is going on in the case. The website address is jjconsulting-receivership.com. Again, that's jjconsulting-receivership.com. So again, if you've not registered, I do encourage you to do so. At this point, I'm going to jump onto the chat and see if there's any questions that are in here that I cannot see, that were not previously answered, as I'm hopeful that I can get through these and get some answered. So first one from Joe says, you said the return will be greater than 22% of the claim. Can you clarify a better range? Unfortunately, I cannot clarify a better range because I don't yet know what that number is. However, we do anticipate that number will continue to grow as we collect more assets and litigate a lot of these third-party actions. We do believe there is still tens of millions, if not hundreds of millions of dollars out there, including the litigation that we've already filed and litigation that we will be filing. One of the questions has to do with the specific home in San Clemente. Just know that particular asset is being dealt with as we speak, and will continue to do so, and that we don't anticipate that person will be living in that home much longer. Can we have an updated timeline on the claims process? Again, my hope is to get it filed in June. There's some things that have to be done as part of that, and then of course the court will have its hearing on the claims motion, and so that'll usually take an additional few weeks to get that scheduled and heard. So that's kind of what that looks like right now. Next one from Joe again. We were originally told that investor names were kept private and assigned ID numbers to protect their privacy. Can you assure that? I can assure you that the investors' names are being kept private. The only time that we release that information is either to the court or to, for example, in the Wells Fargo litigation, we were required to turn over, but it was done so with a protective order, so that the data cannot be used for any other purpose other than allowing Wells Fargo to do their own calculations as to what they believe people are owed. But we do not ever, provide investors' names publicly. Will there be a distribution in 2025? We do hope that there will be a distribution in 2025. There's some things that definitely need to fall our way, but that is our hope. Do you issue a 1099 when a claim is distributed? Typically, no, because they're distributed as part of a fair fund, so their 1099 will not be issued. However, I do recommend you speak with your tax accountant regarding the need for that and what that looks like. Next question says, I've changed banks since the receivership started. How do I ensure that claims are sent to the correct bank account? So it's likely in this case that payment will be made via check, and it will be made to the payable to the information as part of the claim. So when you file your claim, make sure that you have your most updated information on that claim form. And if we send something to you and it has the wrong information on it, please do update us. If you have questions or you want to ensure that we have the correct information for you, if you've moved recently and just want to make sure, then I do recommend that you reach out to us and provide us that new information via email. So some of the next one says some of the J&J principals and related people may have transferred their assets to offshore accounts or protection shelters, such as trusts and such. Are you able to claw them back? To the extent that we know of assets, we will definitely seek to claw them back, no matter where they're located. We do have the ability to do so. So if you see or if you know of anything like that and can provide us any specifics, I encourage you to please provide us that information, either email us or contact us directly. It says Michael Murphy bragged about a horse ranch, horse breeding and stables in Texas. Has this been investigated for clawback? Yes, it has been investigated, and we are in the middle of continuing to do so. Next question is, how much have the attorneys been paid thus far? I don't have that number off the top of my head, but in my next report, I will put that information in there so it's available. So instead of having to look over multiple reports, you can see it in one place. But if you do want to see how much that is, there's two places that will be in the standardized financial accounting report. The amount of payments to professionals will be in there, keeping in mind that that is both my team as well as legal counsel. Will be in there, and so each quarter that shows up in there, as well as the disbursement. So we list out all the payments that are received and paid out from the estate, and so that information is there as well. When we meet again with Wells Fargo for settlement discussions, so we're actually in discussions with Wells Fargo right now on setting up another mediation, and we don't yet have that date. How much money is needed in recovery to make investors whole? I think we estimated that number to be approximately $246 million to make investors whole. What is the probability for punitive damages through Wells Fargo? Punitive damages are never guaranteed, and so we don't know, what or if punitive damages would be available. Obviously, if we mediate the case and we settle it, there won't be there wouldn't be punitive damages in that case unless that's part of the number that we negotiate. If we go to trial and we win, there is an opportunity for punitive damages, but they are far from guaranteed. Next one, discussing defendants living in a multi-million-dollar home on the beach. Will that be sold? Yeah, any assets that have any value whatsoever will be sold in order to make up for any money that needs to be recovered in order to try to make investors whole. Now, keeping in mind that just because somebody has an expensive asset does not necessarily mean that there's any value there. It could be that they're mortgaged. It could be that that there just isn't any value in the asset. So we do have to look at that. And if we determine that there isn't value, or that the value would be exceeded by the cost of liquidating the asset, then we would not obviously take on something that could create a liability for the estate and cost investors money. So that is something that we weigh out. Again, that goes back to that cost benefit analysis. So again, those are all the questions that I see in the chat. I hope I was able to answer as many of them as possible. To the extent you still have additional questions, I do encourage you to reach out to me and my staff using either the contact email address or the phone number. If you have any other questions, then please do send them that way. Otherwise, I appreciate you guys joining us, and thank you for taking the opportunity to have this call. And again, I apologize for needing to reschedule it very quickly last week. Thank you very much, and look forward to continuing to work with you.